Hi everyone and welcome back to my YouTube channel Let's Study Law. Today we are going to discuss the topic of bailment, which starts from section 148 to 171. So this will discuss each and every section along with case law. So section 148 defines bailment. Bailment is the delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, return or otherwise disposed of according to the direction of the person delivering them. They are essentials of this definition and you will understand better the definition. So let us start. Whenever we study the chapter of bailment, it is necessary to note what are these two words, that is bailer and bailee. So bailer, you say a person is bailer when he gives, and the person is called bailee when he takes. That is when someone gives the goods, then he is known as bailer, and the person who takes the goods is known as bailee. Now let us start with the essentials of bailment. The first essential is delivery of goods. There must be delivery of goods from one person to another, then only there arise a contract of bailment. This can be understood better with the help of the case law, which is Utzon versus Nichols. So here there is a person, let us constitute as A. He goes to a restaurant, okay, and then there a waiter takes the person's coat and he hangs. Now after the person finished the dinner, he asks the waiter for his coat, and waiter states that he lost the coat. Now from this case, two questions arises. That is, was there a bailment of contract between two, that is A and B, between the person who came for the dinner and the waiter, and can A sue B for loss of coat? So now let us answer to the question, is there a bailment? Yes, there was a bailment. Now let us clear why there was a bailment, because the petitioner A and the waiter B didn't had any contract that okay, yes, you will take my coat, okay, yes, after the purpose is finished you return it to me. There was no such contract. But there is one more thing which need to be understood, that there must be entrustment also with the delivery of goods. Yes, there was no contract between the petitioner A and the waiter that okay, A will tell that okay, waiter, now you take my coat. Waiter came voluntarily and he took the coat, and A had an entrustment, he had trust. Okay, after I finish my dinner, he will return it to me. Therefore, the person who gave the coat, the person who came for the dine, he was considered to be the bailer who gave the good, and the waiter who took the coat, he was, and the waiter is known as bailee. There was an entrustment, there was a trust between the person who came for dining, he and the waiter, and it was responsibility of the bailee to take care of the good. And when the purpose is finished, that is when A finishes his dinner, it was the duty of waiter to take the coat and give it to him. Hence A, that is the petitioner, can sue B, the waiter, for the loss of coat. Now let us move to the second essential, which is delivery should be made upon contract. So there must be contract between the bailer and bailee. The bailer should tell that okay, now you take care of this good, still I come, or you can use this good, and the bailee accepts. So there must be contract, this kind of contract. So you will better understand with the help of this case law, that is Ram Gulam versus State of UP. So in this case, there was a person, let us name as A. Some property was stolen. Okay, now then it was recovered by police. Now in this case, B is the defendant, who is the police. In A got stolen and it was recovered by police. Now the stolen property was kept under police malkhana. Again it got stolen from there. Now A states that since it was under the custody of police, there was a contract of bailment, and and police should be liable for this. That is, the state must pay compensation. Now let us see that was the police held liable for this action. So the court observed that there was no contract of bailment, because there was no contract between A, whose property was stolen, and B was the police who recovered the property. There was no, between them there was no contract of bailment, that okay, A did not give his property to the police, nor it was like something like, okay, now sir, you use it, policeman, you use it and give it back to me. There was no contract between them. Now so here court held that, first thing, there was no contract. Second, it was the duty of police to keep the stolen property under police makhana. The possession is there because he was acting in discharge of obligation under law. Okay.
So, here, in some cases, the contract of bailment would be valid with or without contract. So, in this case, that is the state of Gujarat was Mehmoon Mohammed. In this case, let us move to the facts of the case. So, here A is the custom authorities and B is the petitioner and A is the defendant. Okay. B petitioner. So the custom authorities seized 2 trucks of the petitioner on the grounds that he had not paid the import duties and the trucks were used for smuggling goods. Then the tribunals directed the custom authority for the return of vehicles. B, being the petitioner, was the petitioner, applied for the return of vehicles, and he was told that the vehicles were disposed under order of magistrate, but it was later known that the order obtained was under false representation, claiming that the property was unclaimed property, stating that the property was unclaimed property. Then B, being the petitioner, filed a case and it claimed either the vehicle or the alternative is 32,000 rupees. Now A was the custom authorities was liable because it was the duty of the government to take care of the vehicles when the tribunals were when the order of the tribunals was to return back the vehicles to the petitioner. By this we are clear that the contract of bailment can arise with contract or without a contract, which means that the bailment is dealt with by the Contract Act only, but where in case where it arises from a contract, but it is not correct to say that there cannot be a bailment without an enforceable contract. Now we'll move on to the third essential and the last essential of section 148 of bailment is that the delivery should be upon some service. Now section 149 defines delivery. So the delivery are of 2 kinds. As section 148 says that there must be delivery of goods from one person to another in order to constitute the contract as bailment. So here 149 section 149 defines that there are 2 kinds of delivery, and if both the kinds of delivery, either the one or other, is done, then it would constitute as contract of bailment. Okay, so the actual delivery meaning is that the physical possession of goods have been given to the person who is the bailer, bailee. The constructive delivery means that the physical possession of goods is not given from one person to another, that is from bailer to bailee, but there is something done in order to give the rights of the possession. Understand with the help of example. Example A is a petitioner and his car is not working, and he goes to B, who is the garage owner, and hands over him the keys of the car and tells that take my car from my home and repair it. So here A is not giving the actual physical possession of car, actual physical possession of car, which means he is not taking car and coming and then living in the garage of B. He is giving him the keys, which means that now B, being the bailee, has got the possession of car. Okay.
Thank you for watching my video. Please do like, share and subscribe my YouTube channel, that is Let's Study Law.